it to be criminal negligence, and that may put you in jail or fine you. Some other things, some things are criminal. Some things criminal are criminal because they've been statutorily imposed, and others are through common law, where judges make successive decisions. So, whoops, just go back one there. So if you look at it like that, you find that, for instance, say take murder in the state of New South Wales, Victoria, and South Australia. At least, I'm never quite sure about the territory, so I'm not going to tell you about that because otherwise I might prove myself wrong and look silly, and I look silly enough as it is. The criminal law, statute law, is in New South Wales, Victoria, and South Australia are generally common law, and this is where common law comes in again and starts to get a bit confusing. We're not saying that they are the English derivative law, although it so happens that they are, but common law also denotes a notion of judges making the law over a period of time, which you looked at in the last slideshow. Okay, so if you wanted to charge someone with murder in New South Wales, Victoria, or South Australia, then the Department of Public Prosecutions would look at the criminal law cases, but it would also look at the statute. So it would look to see if there's a federal statute or maybe there was some other crime statute that had been passed, which made a particular act a crime. If you go to Queensland, Tasmania, or Western Australia, what they've done there, it's a strange thing, is that they've actually codified the act, which means they take all of the case law and they put it into, they say, look, this is a body of law that existed up until this point. Now we're going to write it all up in a book, going to call it the Criminal Code Act or Criminal Code, or the Crimes Act, whatever you want to call it. And then we're going to say that from now on everything has to be in this, and it excludes everything outside of it. And that's all well and good up until the first day it gets used, and as soon as it gets used, judges have to come along and interpret it. So in fact the judge-made law comes in, you end up with a combination of both the statute law and judge-made law. Now some things are civil, some things civil are statute and common law, also applies to civil law, or does apply to civil law I should say. Civil statute law, I'll give you an example of this. Probably the best way of explaining it is to say, look, initially, if I have a contract, so I go down to Woolies and I decide to buy myself a big fan because it's hot down here at the moment, and I say, okay, I slip into Woolies, grab myself a fan, out to the checkout, and off I go. Get back, turn it on, and nothing happens, right? Back in the bloody car, drive down to Woolies, come in there, hey, I bought this fan, doesn't work. That's no good, but too late, because you bought it and you've walked out of the shop, go away, not interested. Now I would argue that that's a breach of contract, because I'd say the contract was to purchase a fan that worked, not one that isn't working. It is not, not a live fan, it is a dead fan. It's pining for the fjords. It's dead, right? It's one dead fan. Okay, they say, but you know, what gives you the right to do that? Well, it could be the common law of contract, which is the case law of contract, just the cases, all the cases preceding it, which clearly state that that would be a breach of contract. But also there's a civil law statute law in the Trade Practices Act, which is federal, but covers all the states, and that is, and particularly seeing as Woolies is an organisation, it's a corporation under the corporation powers of the Constitution. Section 51 of the Constitution allows the federal government to make legislation regarding corporations, and it's imposed Section 52 of the Trade Practices Act. You don't have to know all of this, I'm just explaining it to you. Section 52 of the Trade Practices Act, which covers things like merchantable quality, misleading conduct and so forth, and they'd be in breach of that. Might be 53 as well, and I think Section 82 then gives you remedies. So the breach of contract, as you can see, is in both those intersections of statute law and common law. Now, over on top of this, there's another thing, which is the principles of equity. We're not going to go into that, right, because they're very complex things. Principles of equity. Equity is an entire year's subject in a law degree, as is the Trade Practices Act, as is the Common Law of Contracts. So you can imagine there's heaps to learn in this stuff. You need, and even then you walk out going, what was that about, So it can be easy to just to not know what's going on. But don't worry about it. It's not something you need to know. But the idea is, so go back to the beginning. The essence of it is to say, look, folks, essentially things work this way. You have there's common law and there's civil law. But sometimes common law and civil law mean legal systems. Other times common law and civil law mean common law being judge-made law, civil law being an action between individuals or individuals and the state, which is about compensation. Okay, and that's pretty much it, really. So I'm going to leave you with that. You can look through it a few times. If you've got any questions, give me a ring. I'll tell you all about it. Here's me bus. I better go.